Every filing, every interview, every statement at a port of entry goes into a permanent record, and USCIS is always cross-referencing it and checking all of it every time you file a benefit request. The most common fraud risk in EB-1A and National Interest Waiver petitions are not the inflated story you're telling on a letter or a personal statement. They're actually the profile building activities and shortcuts that seem harmless but can permanently damage your credibility. If you profile build and you do what your friend did, your profile is going to look like your friend's. You're not going to stand out. National interest waivers and EB-1As, especially EB-1As, are built on evidence that is organic and accumulated over time. You are not going to build an EB-1A profile in a year. It just doesn't work like that. So if you're preparing to file an EB-2 National Interest Waiver petition or an EB-1A, there are many things that you can do inadvertently to damage your case. And many professionals don't even realize that they are actually harming themselves rather than helping their petition. Paid publications, pay-for-play media articles, purchase memberships, evidence manufactured in a short period of time. You think you're just checking boxes off on a form, but it doesn't work like that. USCIS is actively looking for patterns, and every petition you filed stays in their system. And you bet that every new petition you file after the one that has been denied is going to be cross-checked. USCIS is going to hold you accountable. In this video, I'm going to explain the most common EB-1A and NIW profile building pitfalls, the specific red flags that USCIS looks for, and how to make sure your case stays defensible throughout your entire immigration journey. Every single filing goes into your permanent alien record, visa applications, your interview answers, even your statements at a port of entry. USCIS is getting better and more sophisticated at cross-referencing everything you said across those filings and holding people accountable every day. Common examples can be things like omitting a family member on a DS-160, then maybe revealing them later. But even if it maybe didn't matter at the time, these inconsistencies look bad over time. Then there's material misrepresentation. It is intentionally offering up information that is false or misleading to get an immigration benefit. So for example, if you are immigrating through employment-based routes, your H-1Bs, I-140s, I-45 adjustment of status applications, it all has to be consistent. And if you're working with different law firms or maybe filing things yourself, you have to be very careful. A practical tip I always give is record keep. Keep a record of everything you ever submit to the US government. Now let's talk about profile building and what I'm seeing that is harming people's chances of getting their cases approved. USCIS has caught on to profile building activities. And it hurts because your case is starting to look like everyone else's. And you're just not standing out. Pay-for-play publications, journals that require you to pay to publish are big red flags to an immigration officer. There are so many nonsense journals out there that people are just publishing papers left and right to get citations. But let me give you a practical tip if you are publishing. Check Google Scholar metrics to make sure that the journal is on a database that is indexed. And let's talk about pay-for-play media articles. I really hate these. There is no reason why somebody working behind the scenes is getting a profile piece about them in some obscure magazine somewhere, talking about the evolution of technology. Guys, just stop. Now let's talk about memberships. There are many professional memberships that require payment in order to become a member. And the payment is fine. However, if you're gonna be including memberships in your petition, you should also include the service that you're providing to that organization. The membership itself, if you're just buying it just to check off a box, it's not gonna help your case. Now I want to talk about another huge red flag, the timeline red flag. Everything you've done, judging, publications, media, membership, if it's all done in a very short time frame, that's going to raise a huge red flag to the USCIS officer. And even if you get 3 out of the 10 criteria in your EB-1A petition, it's probably going to fail on the final merits. For EB-1A, the evidence needs to be built organically over time. Now, the same applies to national interest waiver petitions. Though I don't see the same level of profile building in NIW petitions as I do in EB-1As, we can still learn a lot of lessons from this video. And the same cautionary tales apply. USCIS is looking at the legitimacy of your evidence. If they conclude that you are engaging in misrepresentation or profile building, that's a mark on your record, and you do not want to have a letter like a notice of intent to deny or denial claiming that you misrepresented a material fact. Remember, if your case gets denied and you refile, they're going to have your refile and your case probably side by side, making a comparison. It just does more harm than good to keep refiling things over and over and engaging in these profile building activities that really bring no strength to your case. If you're preparing an EB-1A or an EB-2 National Interest Waiver petition and you want to make sure that your evidence is credible, that your case is persuasive, you can request a free case evaluation using the link right below here in the description of this video. My team and I will review your background, assess the strength of your case and the legitimacy of your evidence, and help you determine whether you are ready to file. And if you need areas of improvement, we'll let you know as well. And of course, you're able to talk to us and we'll help you develop that strategy that actually works. So remember, friends, please, if somebody's offering to help you write an article so you can publish in an obscure journal so you can get a citation or whatnot, don't fall for it. Don't pay for it. If your petition gets approved with questionable evidence, especially if you're outside of the United States and or inside the United States filing adjustment of status, that USCIS officer who's adjudicating your immigrant visa or your adjustment of status is going to have access to that petition. So keep that in mind. I have seen cases where people have an approved I-140, they are outside of the United States, and the consular officer is questioning the credibility of that I-140 and sends it back to USCIS for re-adjudication. It can happen. We are in an era of heightened scrutiny. Do everything you can to stand on the ethical side and distance yourself from anything that is questionable. Your future green card will thank you for it. Let's talk about how you can protect yourself by choosing the right kind of legal help. A notary, a paralegal, or a consultant are not the same thing as a licensed immigration attorney. Every U.S. attorney is licensed in a specific jurisdiction, and you can look them up in their state bar database. And you can verify that they haven't been disciplined and that they are in good standing. Most immigration attorneys are also members of AILA, the American Immigration Lawyers Association, and you can look them up. And when a lawyer files your case, they are going to ask you to sign what's called a G-28. That is a document that enters the attorney as your attorney of record on your case. If the person preparing your case does not give you a G-28 to sign, that person is not authorized to be practicing law or give you legal advice. Run away and run away fast. Now, one of the things that I talked about in this video is that USCIS is looking at the legitimacy, the objective credibility of your evidence. And that is especially true in self-petitions like EB-1As or national interest waivers, where the adjudication environment is getting extremely tight. And if you're preparing a national interest waiver petition right now, one of the biggest reasons why cases are not getting approved, it's actually not fraud. This is a new development that I want to make sure that everybody's aware of. And the reason for the denial is often because the proposed endeavor is just too vague, too aspirational, too unbelievable. Immigration is saying that they cannot easily understand your proposed endeavor or that you didn't submit one to begin with. And that sometimes is maddening. In the next video, I explain exactly what USCIS means when they say an endeavor is too vague and why this is causing denials for strong applicants and how to avoid this mistake when preparing a petition. The video is right here. I'll see you there.